Good morning, everyone. Thank you for joining me today. For those who don't know who I am, my name is Peter Doughman, and I'm Associate Lawyer at Matthews Folbigg Lawyers in Parramatta. Today's presentation will be a little bit different to ones that I've normally given in the past. Unlike previous meaty subjects of old, today I'll be endeavouring to give a hopefully concise summary of what's new and upcoming in 2019 in the employment and industrial relations space. Before I begin, I'll just mention that I'm happy to take questions from any viewers. I'll do so at the end, so please feel free to submit any questions you have during the presentation using the system on your screen. So today's presentation obviously could cover a lot of subjects and topic areas, but I propose to focus on the 6 areas of focus on your screen. Firstly, the domestic and family violence leave in the national employment system, the new protections against casual double dipping in the Fair Work regulations, conversion rights for casual employees on all modern awards, the new, or should I say proposed, annualised wage arrangements in modern awards, the relaxation of approval requirements for enterprise agreements, and finally we'll have a look at what's on the horizon for 2019, including after the upcoming federal election. So let's start with the first subject area, domestic and family violence leave in the NES. Most employers should hopefully know that all modern awards were recently amended to incorporate entitlement for domestic and family violence leave for those employees covered by the awards. Obviously that left out in the cold those employees who were award or enterprise agreement free. So with that in mind, late last year, the federal government passed legislation to grant an entitlement to domestic and family violence leave on all national system employees, whether or not they were covered by a modern award or an enterprise agreement. And as I said before, that was an entitlement previously limited to employees covered by awards or enterprise agreements. So the NES entitlement allows employees to take the leave when there are in the context of family and domestic violence. And that's defined as to mean violent, threatening or other abusing behaviour by an employee's close relative which seeks to coerce or control the employee or else causes the employee harm or fear. Now you'll see from that definition that it doesn't require actual physical violence to the employee, and that means that the employee doesn't need to actually show signs of abuse, physical abuse, in order to request the leave. Now the entitlement, in a nutshell, is 5 days of unpaid leave within a 12-month period. There was a bit of back and forth between political parties, including the Greens, who wanted the entitlement to be a paid leave entitlement. Unfortunately, that was defeated. And so the entitlement is for 5 days of unpaid leave within each 12-month period. Now, importantly, the leave entitlement applies to all national system employees, including casuals, unlike other entitlements in the NES, other leave entitlements in the NES, such as annual leave and personal leave. Casuals get the benefit of this leave too. Importantly, and different to all other forms of leave, the entitlement arises at the commencement of employment and at each annual anniversary of the employee's commencement. So in other words, the entitlement to leave starts at day 1 of employment and then recrystallises at day 366. It doesn't accrue through the year like other forms of leave. And finally, the entitlement does not accumulate from year to year. So for any leave that the employee doesn't need to take during a year of service, that gets lost or forfeited, and the entitlement to five days per year begins again upon the anniversary of the next or the following year of service. So the leave for domestic or family violence can be taken in order to deal with the impact of the family violence, and that includes making arrangements for the employee's own safety and the safety of the employee's other family members, such as children, and that can include relocation arrangements, similarly crisis accommodation, attending court hearings, or to access police services. Now the leave can be taken either all at once in a 5-day block or a single or multiple days over the year of service. And finally, the NES entitlement is a baseline that allows that the employer may have a policy that contains more favourable entitlements. So, for example, an employer may provide all employees with entitlement to 7 days of paid leave for family and domestic violence. In that case, that entitlement would beat the NES because it's more favourable. The employee does not get the benefit of the 7 days of paid leave plus the 5 days of unpaid leave. Like all other forms of leave, the employee has to comply with the notice and evidence requirements. In relation to notice requirements, firstly, the employee must request the leave as soon as possible, and that could include after the absence has started. And the employee must advise the employer of the expected duration of the leave. That doesn't have to be specific. The employee can give a general estimate of the duration of the absence, but it should be enough to give the employer some detailed information as to how long the employee will be away and to make arrangements for replacement duties or replacement workers if need be. In respect of evidence requirements, after a request is made, the employer can request evidence of the need to take the leave. The employee doesn't need to provide the evidence in and of itself unless the employer requests the evidence. And if the request for evidence is made by the employer, the evidence given by the employee must convince a reasonable person of the need to take a domestic or family violence leave. That could include evidence such as police records, court documents, family and violence support documentation or statutory declarations, as the case may require. Now, in respect to any evidence given by the employee to the employer has a strict obligation to take reasonably practicable steps to keep confidential that information received in support of the application for leave. That requirement is subject to exclusions where the employer can disclose the information if required by law, for example under a subpoena, or if it is necessary to protect the life, health or safety of the employee or another person. You'll note that that second limb requires the employer to exercise judgment as to whether the situation is sufficiently dire to justify the disclosure of that confidential information. I would suspect that given the health and safety risks of disclosing the information in the context of domestic and family violence, that that disclosure should only be made in very exceptional circumstances. And finally, it's worth noting that breach of the confidentiality may have serious adverse consequences to the employee, as mentioned before. But interestingly, the Act does not provide an entitlement to compensation for any breach. The employee may have entitlements under privacy laws, but they are only in very narrow circumstances. So let's move to the next subject area, and that is the protections against casual double dipping. Now, double dipping in this particular context relates to claims by casual employees for entitlements that casual employees do not have, and it rose in response to the outcry following the federal court decision in Workpac and Skene in, I think, August 2018. And I'll go through the facts of that case in a short while. But essentially, Mr. Skene was awarded entitlements to annual leave, notwithstanding the fact that he was employed ostensibly as a casual. In response to that outcry, the federal government in December 2018 amended the Fair Work regulations, not the Act, the regulations, so as to introduce employer protections against casual double dipping claims. For those who are interested in, or like doing the research or doing their homework, the regulations are located in Reg 2.03A of the Fair Work regulations. And I'll go through what those provide in a moment. I should outline what double dipping means in this context. In the context of this particular regulation, a double dipping claim is one where an employee is employed on a casual basis and paid an hourly rate of pay which includes or is purported to include casual loading. The employee subsequently asserts that he or she was in fact a permanent full-time and part-time employee, and the employee then claims unpaid entitlements under the NES associated with permanent employment, such as annual leave. It could also include paid personal leave as well. So the decision of Workpac and Skene, you may have heard that, or you may have heard a decision such as this report on the news, and it has certainly caused an outcry. Whether that outcry is warranted is maybe up for debate, because the full court of the federal court makes clear the rationale for its decision, and I'll get to that in a moment. But in terms of the facts, in essence, Mr. Skene was ostensibly employed by Workpac as a casual employee, pursuant to the Workpac Enterprise Agreement, as well as a contract of employment which confirmed the terms of the EA which applied. Mr. Skene was subject to a continuous 7-day fly-in and fly-out roster. He worked regular and systematic shifts. He stayed in accommodation near the mine, or even on occasion accommodation arranged by the mine, and most importantly was expected to attend each shift that he was rostered. He was paid a flat and elevated rate of pay, which purported to absorb, he was paid a flat or elevated rate of pay, but his contract did not state what entitlements that elevated rate purported to absorb. After his termination, Mr. Skene claimed that he was not in fact a casual employee during his employment and sought the recovery of annual leave entitlements per the NES. So this went through a few different hearings, and the full court of Federal Court of Australia found in favour of Mr. Skene, and in so doing reiterated that the NES has supremacy over all industrial instruments. In other words, employers cannot contract out of NES entitlements, including pursuant to enterprise agreements or contracts. And nothing within the EA or the contract stated the elevated rate of pay was inclusive of the casual loading. And that defeated the attempted double dipping claim that the employer sought to bring, the set-off claim that the employer sought to bring. The court found that Mr. Skene's conditions of employment did not show that it required, and this is the test they used, informality, uncertainty or irregularity for casual employment. So just because Mr. Skene was classified as a casual as per the EA did not change the true nature of his employment as other than casual, which is specific terminology used in the NES, where it applies to the entitlements that other than casual employees can get, such as annual leave and paid personal leave. And accordingly, the court held that Mr. Skene was entitled to annual leave as per the NES because he wasn't a casual employee for the purpose of the NES. So Reg 2.03a provides, well, firstly it applies if a person is employed on the basis that the person is a casual employee. In other words, the person is asserted to be a casual employee by the employer. The employer pays the person an amount known as the loading amount that is clearly identifiable as the amount paid to compensate for not having a relevant NES entitlement, such as personal leave or annual leave. And during the employment, the person was in fact an employee other than a casual employee. Again, that's other than a casual employee. That's the terminology used in the NES and the Fair Work Act. And finally, the person makes a claim to be paid an amount in lieu of the relevant NES entitlement. So, as I mentioned before, a relevant NES entitlement means an entitlement under the NES which a casual employee does not have. For example, annual leave or paid personal leave. So if the regulation applies, it provides that the employer may make a claim to have the loading amount taken into account in determining any amount payable to the person in lieu of a relevant NES entitlement. And it operates both prospectively and retrospectively, which is important because there are a number of claims being made following the template of the Skene and Workpac decision that makes similar claims for permanent employment entitlements for casuals. And those are still in the process of being determined and heard by courts. Now, I've set out what the regulation provides, but it does not provide that a person who received the loading amount is barred from making a claim. So it's not a statutory bar from making a claim. It does not provide the fact that the loading amount was paid will automatically defeat any claim made by the employee. And it does not provide that the court is required to take the loading amount into account. So, reading between the lines, the regulation is less than comprehensively deals with the issue in the Workpac decision. It only really allows that the employer can apply to the court to have the loading amount taken into account to offset any claim made by the employee but doesn't require the court to do so. So will it be effective? My view, probably not. The regulation only applies when the loading amount is clearly identifiable, and that's, I think, the key takeaway here. So when an amount is not clearly identifiable, for example, it's not listed as a specific amount in an enterprise agreement or a contract of employment, then it's unlikely that the regulation will apply. In other words, it cannot be relied upon when there's no contract or the rate of pay is not expressly inclusive of casual loading. And I think part of the reason why the regulations have been shown to be less than comprehensive or less than useful is that despite requests from all corners of industry, but especially from employer organisations and associations, the regulation does not amend the Act or else otherwise provide a definition of casual employees. So it's clear that the issue will remain live at least until there's a clear statutory definition of casual employment. Having regard to all of this, we think that employers must ensure they have written contracts of employment for casual employees which make clear the rate of pay is inclusive of casual loading. Otherwise, let's wait and see what these court cases determine and whether the regulation is invoked by the parties or by the court. The next subject area is conversion rights for casual employees. Hopefully some of you would be aware of this requirement, and if not, it's a timely update and timely time frame to tell you about it now because of a specific deadline which I'll get to in a moment. So firstly, in October 2018, 86 modern awards were varied to introduce clauses entitling casual employees to request conversion to permanent employment. Now, permanent employment is obviously either part-time or full-time employment. Now, the right to convert applies to a regular casual employee, and this is defined as an employee who works a pattern of hours on an ongoing basis where the employee can continue to perform as a full-time employee or part-time employee without significant adjustment to their hours. Now, the right to request conversion arises after the casual employee has performed 12 months of regular casual employment. Interestingly, for those awards that have existing casual conversion provisions, these amendments have not affected those awards. Now, the right to convert, as I said, arises where the regular casual employees have worked over the preceding 12 months. Now, for equivalent full-time hours, the employee may request to have the employment converted to full-time employment. Where the employee has worked less than equivalent full-time hours, the employee may request to have their employment converted to part-time employment consistent with the pattern of hours previously worked. So if you're working, in other words, if an employee is working, casual employee is working ostensibly full-time hours, they can request to convert to full-time employment. And if casual employee is regularly performing less than full-time hours, they can request to convert to part-time employment equivalent to the hours they're already working. Now, under these new clauses, the request to convert to either full-time or part-time employment must be made, firstly, by the employee in writing. The request must be genuinely considered by the employer, and the employer must consult with the employee about the request. The request may only be refused by the employer on reasonable business grounds, and the response must be provided by the employer in writing within 28 days of the request being made. Importantly, the clause does not require the employer to agree to the employer's conversion request, and the test for reasonable business grounds is the one the employer can rely upon if it considers the request to be inappropriate. Now, reasonable grounds include the conversion would require a significant adjustment to the employee's hours, or it is known or reasonably foreseeable that the employee's position will cease to exist in the next 12 months. The hours of work which the employee is required to perform will be significantly reduced in the next 12 months, or there will be a significant change in the days and or times at which the employee's hours of work are required to be performed in the next 12 months. Now, notice that these are examples. That's not an authoritative or comprehensive summary of what reasonable business grounds the employer can rely upon, and the employer can raise other reasonable business grounds in support of any refusal. If the employer does, the employee can challenge the decision pursuant to the dispute resolution clauses contained in the relevant award, which requires the employee to bring a notice of dispute to the Fair Work Commission. So employers of casual employees covered by these awards must provide a copy of the conversion clause to all casual employees employed as at 1 October by the deadline of 1 January 2019. Now, I note that's already passed. So if you as an employer have not already done that, if you currently employ casual employees and you know that, or you've discovered from investigation, that the award that covers your casual employees contains a relevant casual conversion clause, you are required to notify them as of 1 January 2019, but if you don't, I recommend you do it as soon as possible. And for those the employer must also provide a copy of the conversion clause to all casual employees employed after 1 October 2018 within 12 months of starting employment. In other words, for those employees commencing after 1 October, you don't need to give it to them immediately, although I think it would be prudent to do so. You just need to give it to them within 12 months of commencement. Now, where a request for conversion is agreed to by the employer, the terms of the conversion must be documented in writing. The award provides that the agreement is a time and wages record for the purpose of the Act, and the employer must also take care that the agreement contains any necessary terms that the award requires to be documented in writing in respect of part-time employees. Certain awards require that for part-time employees, the employer or the employee agree to or confirm in writing the agreed hours of work. So I'd also recommend that if a conversion is agreed to, that you take all reasonable steps to make sure that you document in writing everything that the award requires you to confirm for either part-time or full-time employment. Let me just see where I'm up to. Okay, I'm moving on to the next section, which is new annualised wage arrangements. Now, this is actually this is a subject that I would say is probably more pending than new. It seems all but certain to come into effect shortly, following a decision in both early last year and just a few weeks back this year, where the Fair Work Commission, as part of its 4-yearly review of modern awards, considered appropriate to standardise the annualised salary or annualised wage arrangements in awards that contain them. And they propose, following a decision, to insert standardised wage provisions either under one of two possible categories. They haven't confirmed the incorporation of these standardised terms yet because they're waiting for final industry feedback before making the decision. So the takeaway is to watch this space, but start preparing for the incorporations now. So for those of you who are aware, there are a number of awards that contain annualised salary provisions within them, and those annualised salary provisions require that where an employee is paid a above award rate of pay, whether it's hourly or an annualised salary, an annual salary, that salary or wage must be inclusive and expressly stated to be inclusive of certain entitlements. And if a contract of employment does not expressly state in writing that the salary or the wage is inclusive of those entitlements, then the employer is exposed to a potential underpayment claim for those entitlements, even though the employer and potentially the employee understood that the salary was intended to incorporate those entitlements. So the standardised clause will be inserted into various awards covering industries such as mining, farming, banking, hospitality, health and legal services, and I'll set out most of the awards in a moment. And it provides that existing annualised salary clauses will be standardised in accordance with the decision. The takeaway is that each employer will need to check their award coverage in order to determine whether the awards are subject to amendment. So the standardised clauses, as proposed by the decision, will take one of two possible forms. They're defined as either Model Clause 1 or Model Clause 3. The decision referred to Model Clauses 2 and 4 and are not intended to be adopted as model clauses, but they are going to be used in respect of two specific awards, which I won't get into now, but bear in mind that 2 and 4 do exist, but not in a model capacity. So firstly, Model Clause 1 is drafted in mostly identical terms to Model Clause 3, except that Model Clause 3 requires the annualised wage arrangements be documented in a separate written agreement, which must be kept as a time and wages record. And Model Clause 3 also provides the annualised wage arrangement may be separately terminated, either with 12 months' notice or by agreement at any time. So the takeaway is that employers who wish to subject their employees to annualised wage arrangements, where their award that covers the employees has these new or will contain these new annualised wage arrangement clauses, essentially employer and the employee must agree in writing to the terms of it, whether it's in the original contract of employment or in a separate document. Now, the decision proposes to insert Model Clause 1 into the following modern awards. So you'll see there I've listed most of them, not all of them, but these are most of the ones that I consider to be likely to be the subject of people viewing this presentation. That includes Banking, Finance and Insurance, the Clerks Private Sector Award, the Contract Call Centres Award, Legal Services Award, the Mining Industry Award, and the Telecommunications Service Award. So if you know that any of your employees are covered by those awards, expect that Model Clause 1 will cover or be inserted into your award shortly. For those employers whose employees are covered by the Broadcasting and Recorded Entertainment Award, the Local Government Industry Award, the Manufacturing and Associated Industries and Occupations Award, the Oil Refining and Manufacturing Award, the Pharmacy Award, or the Rail Industry Award, expect that your award will be amended to incorporate Model Clause 3. And as I said before, Model Clause 3 is virtually identical to Model Clause 1, other than it requires a separate written agreement, separate to the contract of employment. So let's get to the nuts and bolts of what the provisions require. Annualised wage arrangements under the awards must be limited to satisfy one of the following entitlements: minimum weekly wages, allowances, overtime penalty rates, weekend and other penalty rates, and annual leave loading. In other words, for employees who are proposed to be covered by an annualised wage, that annualised wage can only capture those entitlements under the award. It cannot capture anything else. So it cannot capture other loadings or other allowances. So the employer must advise the employee in writing, that includes by written agreement as per Model Clause 3, of the annual wage payable. That makes sense. It would set out what you as the employer are proposing to pay the employee. Which award provisions are satisfied by the annualised wage? It could be one or all of the entitlements in the list I just put up on the screen. And here it starts getting a bit more difficult. You need to advise the employee in writing how the annualised wage has been calculated, including each specific award entitlement. And finally, you have to advise the employee of the outer limit number of ordinary hours, which attract the payment of a separate amount in respect of penalty rates, and the outer limit of overtime hours, which would attract the payment of separate amount to overtime. In other words, you need to set the ambit for what was captured by the absorption of the overtime and the penalty rate provisions. So that if an employee is required to work an average of, or usually 38 to 40 hours per week, you need to specify that the annualised salary will capture 38 to 40 hours per week. And if an employee is required to work beyond those hours, then overtime would be payable. Similarly, if you specify in writing the employee is required to work Monday to Friday, but the employee is required on occasion to work on a Saturday, then the work performed on the Saturday would not be captured by the annualised salary and would require separate payment. Now, in addition to the requirement to set out the terms in writing, the employer must keep a record of the employee's starting times, finishing times, and the length of any unpaid breaks. Now, I expect this might be a bit onerous and burdensome, but the employer is required by the awards to require the employees to sign off the records each pay period or else roster cycle. And finally, and this is what I think has caused most consternation from industry, the employer must take a reconciliation of the employee's entitlements every 12 months, and the reconciliation is compared to under the award, and must make good any shortfall within 14 days of the reconciliation being performed. In other words, you can't just assume at the time of calculation that the employee is better off overall or above the award entitlements. You must actually perform for each relevant employee covered or subject to an annualised wage. You must perform a reconciliation using the starting times, finishing times and length of any unpaid breaks to ensure that for that 12-month period the employee was in fact more favourably paid compared to under the award. And if the employee wasn't, or if the employees weren't, then the employer must make good the shortfall to ensure that the award, that the employee gets the minimum entitlements awardable by the award. The next subject I think is a bit of good news after what is somewhat of a scary and threatening issue with the annualised wage provisions, and that is the proposed relaxation of the approval requirements for enterprise agreements. Now, for those employers who are have enterprise agreements in place at their workplace, you would be aware that the approval process and certainly the bargaining process is highly fraught, and there's a number of risks for rejection of the enterprise agreement when it comes time to apply for approval to the Fair Work Commission. With that in mind, in December 2018, the Federal Government amended the Fair Work Act so as to relax the strict legal requirements for the approval of enterprise agreements. Now, the wording of the Fair Work Act previously provided that employers must strictly comply with the extensive procedural requirements relating to the negotiation, voting and application for approval of enterprise agreements. And the wording of the Fair Work Act also obliged the Fair Work Commission to reject any application for approval where these procedural requirements had not been complied with by the employer. In other words, the language required mandatory compliance with the procedural steps for both bargaining and approval. And those who have gone through the approval process will be aware that the forms requiring completion are somewhat of a scary prospect. Obviously, these strict procedural requirements resulted in the Commission refusing to approve enterprise agreements for numerous technical reasons, and they have included, by way of example, where the Notice of Employee Representational Rights was stapled to another document, which seems innocuous in itself, but it provided that the Commission found that the Notice of Employee Representational Rights did not contain only the information required by the Act. Similarly, the Fair Work Commission rejected an approval request where the Notice of Employee Representational Rights was on the employer's letterhead, much for the same reason. And perhaps most shockingly, the Fair Work Commission rejected an application for approval where the employer failed to comply with relevant waiting times and deadlines, even when those deadlines and times were determined by the Fair Work Commission's own online calculator. Those who know, the Fair Work Commission has an online calculator determining when bargaining time commences, when the Notice of Employee Representation Rights must be issued, when voting commences, when the waiting period commences, and when the application for approval must be filed. I'm pleased to say that that calculator has now been updated to deal with the error in that particular case, so employers should have reasonable confidence that any compliance with that calculator should get you over the line. But even if it doesn't, these provisions should assist in approving the enterprise agreement, except where the Commission considers it inappropriate to do so. And when is it considered appropriate to do so? Well, the amendments to the Fair Work Act allow the Fair Work Commission to approve agreements, notwithstanding errors, providing that the errors are minor or technical, or where the errors do not disadvantage the employees as a whole. Now, the good news is the amendments operate retrospectively, meaning the relaxed requirements apply to any enterprise agreements that are lodged prior to December 2018, but are still awaiting approval by the Commission. I know in one particular case that we have lodged an enterprise agreement for approval back in December, but have still heard virtually nothing from the Commission about the approval process. And finally, I'll deal with what's on the horizon. Now, this is obviously, I'll deal with some small points, a case that is in process, in train, and I'll deal with, finally, what we expect to see following the federal election. So what's on the horizon? Firstly, for those who don't know, single-touch payroll requirements are now being applied or being rolled out to all businesses, including small businesses. And that's defined within the regular legislation as businesses with less than 20 employees. Now, single-touch payroll is a requirement that payroll systems be digitised, streamlined, and automatically submitted to the ATO following the regular pay period, the completion of the pay period. Now, under the new legislation or under the legislative change, all small businesses must begin single-touch payroll reporting by 1 July 2019. I understand that non-small businesses are already required to comply with the single-touch payroll requirements, so you should already be doing that if you have more than 20 employees. I mentioned this before, but I'll reiterate it, that the casual double-dipping claims are still a live issue, as there are a number of cases currently before the court which are making the same or similar claims to the decision in Workpac and Skene. And time will tell whether these new regulations allow set-offs or casual payments will have any material effect. In other words, whether the employer can claim a set-off for payments made in accordance with the regulation, or whether the court will consider the payment to be appropriate to defeat the claim. And it seems like, as I said, it seems like the power granted the court under this new regulation is fairly minor. It's something that the court could probably have already taken into account even without the regulation coming into effect. There's also on the horizon a test case for the reverse onus underpayment claims under the Fair Work Act. Now this, last year, actually I think it was in 2017, the Fair Work Act was amended to incorporate a section 557C, which imposes a reverse evidentiary onus on employers in respect of underpayment claims where the employer cannot produce payslips or other time wages records. Now, the test case for this one is the Fair Work Ombudsman and A&K Property Services. Now, A&K Property Services is a company that operates 2 sushi trains in Queensland and made a habit of employing a number of foreign workers subject to visas, working visas. Now, the FWO conducted an investigation of that business and including in respect of the payments made, the wages paid to the employees. And in response to a request for production of time and wages records, the employer produced what it described to be reconstructed records. They were not the original or contemporaneous time and wages records which the Fair Work Act requires. And in response to that request, or that production, the Fair Work Ombudsman commenced an underpayment claim on behalf of the employees for amounts that it considered to be remaining outstanding. And those were mainly superannuation contributions. And the reason I say that is because at the time the proceedings were commenced, the employer business had paid back most of the alleged underpayments. So the only amounts being sought in this particular proceeding is, let's say, about $20,000 worth of superannuation contributions plus a pecuniary penalty. The pecuniary penalty is likely to be significantly higher than the amounts being claimed in respect to the underpayments. So it goes to show that simply by making good underpayments following contravention may not get you out of the woods when the FWO comes knocking. Because the employer did not have contemporaneous time of wages records, the employer is, as a consequence of Section 557C, required to disprove the underpayment allegations being made against it. And it would likely, I expect that it will likely fail to do so. So finally, what do we expect to see after the federal election? Well, it's surprising, but we haven't seen much, we haven't heard much from either party about what it intends to do with the Fair Work Act. There has been quite a bit of academic discussion over whether the Fair Work Act requires wholesale update. It seems like both parties are stepping away or turning away from that proposal. But certainly in respect of their platforms, it's clear that Labor is prioritising the increases in minimum wages, and reports from news reports from the last few days have made clear that federal Labor and Bill Shorten is seeking a livable wage, is running on a livable wage campaign. And in tandem with this, the ACTU is proposing a 6% increase to the national minimum wage. And Labor is also running on employee wage protections, which includes reversing the cuts to penalty rates that was made last year. In contrast, the Coalition is prioritising tax relief for small business employers and middle income workers, so both the employers and the employees, but only some employees, and greater protections for working women, which includes being more flexible in respect of the use and taking of unpaid parental leave. Beyond those, it's a wait-and-see situation, and given the changes that were made in December last year, there were a flurry of changes made in December, and most of the changes that I've discussed today were made in December last year by a somewhat anxious coalition. If the coalition does win government, probably there won't be many further changes to the industrial workplace relations landscape. So let's wait and see. That's the end of my presentation. I was going to answer any questions now. I've got about 15 minutes left, so I'll see if there are any questions asked. And let's see. Okay, I have a few questions. Firstly, the question asked is, could an employee make a Skene-style underpayment claim after converting from casual to permanent employment? That's a good question. I think the crux of that question is, if an employee seeks conversion from casual to permanent, wouldn't that necessitate the employee assuming he was, or at least acknowledging he or she was a casual employment employee for that purpose or for that period? And I would say that it wouldn't defeat a claim, even though it does show the employee assumes or was operating on the basis that he or she was a casual, simply because of the rationale for the full court in Skene. That was that the NES has primacy. If an employee is a casual, or more specifically, if the circumstance of employee's employment is truly casual in nature, whatever an award provides, and the conversion provisions arise under an award, whatever a reward provides won't trump the NES entitlement. So if a court finds that an employee was in fact, in regard to all the circumstances of the employee's employment, a casual employee, that employee would not be entitled to NES entitlements such as annual leave. However, if the employee if the full court found that the employee was a permanent part-time or full-time employee, then the court may find that the employee is entitled to certain entitlements under the NES, such as annual leave. Next question is, do the annualised wage provisions operate retrospectively? Well, the decision hasn't, the Fair Work Commission hasn't made its orders to incorporate the annualised wage provisions yet. The two previous decisions suggest that a final decision will be made very shortly once there's a final opportunity for industry to give any final feedback. But I expect that they wouldn't operate retrospectively because typically only legislation can operate retrospectively. Awards operate from the time that they come into effect, or new amendments or variations to awards commence operation at the time they come into effect. So if an employer did not comply with a annualised wage obligation that came into effect as at the time, let me restart. If an employer did not have in place a written agreement which constituted annualised wage agreements for the purpose of the decision, and that decision resulted in the award being amended, then the entitlement to a potential underpayment claim that the employee could bring if the employer failed to update their employment agreement or institute annualised wage arrangements should only be calculated up to and following the commencement of those, the institution of those provisions in the award. In other words, a simple failure to comply with new annualised wage provisions that get inserted to awards wouldn't apply retrospectively before the provisions came into effect. And I think that would be the only way that would be fair. Final question is, what liability would we have if we didn't provide employees with notice of their casual conversion rights by 1 January? Okay, so in respect of that question, note that I assume that applies, you're referring to casual employees who were employed as at 1 October 2018. Of course, for those employees who aren't employed, casual employees who aren't employed as at 1 October, the obligation to provide notice of the casual conversion rights arises after 12 months. But for those casual employees who are employed prior to 1 October 2018, the obligation was to provide the notice by 1 January. That is in itself, a failure to do so in and of itself is a contravention of the award, but it wouldn't give the employee any specific remedy. It may entitle the employee to seek a penalty if it's brought in the context of another claim, or potentially the Fair Work Commission may bring a claim for penalties for a contravention, although that seems unlikely. I think in the event it's going to have any relevance, it would probably be in the context of a dispute application to the Fair Work Commission, where an employer rejects the employee's request to convert, and the employee considers that the rejection is unreasonable, and as a consequence invokes the dispute resolution procedure under the award. As I said earlier, the employee can apply to the Fair Work Commission to resolve a dispute arising under the award, and if, for example, a dispute arising under the award would include a failure to grant a request to convert to casual employment where the employee considers the refusal was not given on reasonable business grounds. And in the context of determining that dispute, the Commission can consider, I expect the Commission could consider whether or not the employer failed to provide the employees with the notice by the relevant time frame. I don't think it's going to go anywhere, but nevertheless, if you're an employer that employs casual employees prior to 1 October 2018, I'd certainly recommend you give employees notice of the casual conversion rights. We can assist with the preparation of that if required, or else you can just do a wholesale cut and paste of the provisions in the relevant award, and that would discharge the obligation. Let me see if there's any other questions. Those are the questions I've got. I've finished a little bit early today, so I'll finish by saying thank you for joining me this morning. I hope you got some information out of this, and I hope it sets you up for a positive and successful 2019. As always, if anyone has any questions arising from today's presentation or wants any further advice on the issues that I've covered today, please don't hesitate to give me a call or send me an email. The contact details for our firm is on our last page of the presentation here. Otherwise, send me an email, drop me a contact number, give me a call, and as always, I'd be happy to assist with any questions you have. Thank you, everyone. Have a good day.